crazy people. Application and appeal in the matter of KLG Trucking SRL and the Secretary of State Land Department.
Please, my lords, I appear for the appellant KLG Trucking SRA, which is the SRL, forgive me, which in terms means limited, with my learned friend Miss Millicent Dewar, who appeared below, and my learned friend Mr. Matthew Howard appears for the respondent in this matter.
Yeah.
I don't know how you want me to begin. I know that there is an extant application lodged by my learned friend to produce what's colloquially known as fresh evidence, and he has provided a application form to that effect. I don't know whether you wish to deal with that first.
Perhaps we should address that for a moment first. Mr. Howard, I think we've all looked at the material. I have to say at the moment I can't see any basis for admitting it, but tell me why I'm wrong.
It's not a matter of whether your lordship is wrong, it's simply the statement itself is adduced, and at least the application was forthcoming on the 12th of April on the basis that it goes to the issue of this appeal, which is an important point in practice or procedure, and it essentially relays the Secretary of State's position as to how they approach the regulations, and indeed deals with the new issues as raised as part of this appeal, and whether or not your lordship finds that relevant to this appeal or not is a separate issue, of course.
Can we just take it by stages? I mean, traditionally one looks at whether the material could have been deployed below, and obviously it could have been.
Yes.
But looking beyond that to what's said, it's not obvious to me at the moment why it's really relevant. The judge had to decide whether to impose a penalty or not, taking into account the code of practice and so on. Why is it going to help us for us to hear more about how the Secretary of State approaches things?
Well, your lordship's obviously asked the question for, well, guidance is sought from the court as to the applicability of the new carriers liability regulations and the amendments in place. The purpose of the statement was to clarify how the Secretary of State approaches these new regulations. The assistance it offers is a more detailed view of the Secretary of State's approach, and that is the evidence at its height.
But if what is being explained is the law, well,
It's a matter for the
it
court.
doesn't actually matter. That's a matter for you and Mr. Clark to make submissions on and us to think
Yes.
about. I'm not quite sure what really more we get out of it.
So be it. It's not an application I'm instructed to pursue vigorously. The height, as I've outlined, of the relevance of this statement goes to the task of the Secretary of State and how the Secretary of State approaches that. What is asked of the court, as we're aware, is guidance on the applicability of the regulations, and it is simply a statement going to the Secretary of State's approach to the regulations and discretion. It's of course a matter for the court whether or not that should be adduced.
Let me just
That's
ask
my
Mr. Clark
application.
what his position is. Mr. Clark.
Well, with the greatest of respect, I agree with my lord. It's not new evidence. It seeks to dissert on the law, which of course is within the compass of this tribunal. But it doesn't actually do what my learned friend says it does. Only 2 paragraphs, and only one of those 2 paragraphs is at all relevant to the way in which the Secretary of State approaches these appeals. But regardless of that, this is not a public law review, and the hearing below was not a public law review of the decision of the Secretary of State. That's trite law. And so how the Secretary of State may or may not exercise his or her discretion is not a matter, with the greatest of respect, for this court.
Mr. Howard, any comeback?
My lord, it's not been proposed on a public law basis. I've outlined the basis of the application and the relevance of the statement. It is simply the Secretary's position as to how they apply the regulations, how they have been doing it so far, and the applicability to this appeal, and that it's simply there as evidence before the court, whose task is to offer guidance on the application of the law. I'll take the application no further.
Agreed. we won't admit the
I'm
evidence.
grateful.
Mr. Clark.
Well, can I start, please, with a brief overview? At the heart of this appeal, I submit, is the question whether a haulier, having done all that the regulations, the new 2003 regulations require of him, should be liable to a penalty because his driver has not done that which is required of him under his share, I put it that way, of those same regulations. The respondent answers this question with a firm yes. Yes, they say, because the haulier, as he puts it, is vicariously liable for the failures of the driver. He is, they say, the agent of his employer. And so the driver's failures are his employer's failures, even where, as in this case, the driver deliberately misleads his own employer. Two brief references in this overview. The respondent's skeleton argument at paragraphs 8 to 9 recite the following. I don't need to take my laws to it now, I shall go to it in due course, but it recites the following, quote, the respondent's case, this is the skeleton argument of the respondent before this court. The respondent's case is that the failure to make records in a checklist is the triggering fact that breaches regulation 2E. The driver failed to do so as soon as practicable, and as a result, the appellant company were vicariously liable for the discovery of the clandestine entrants. I don't think he quite meant that last bit, I think he meant the carrying, but there we are. And the second quotation from the following paragraphs, 8 and 9, quote, they are vicariously liable once the driver drove his lorry into the United Kingdom with 8 clandestine entrants and failed to demonstrate how they are not vicariously liable for their employees. I say nothing about the shifting of any burden onto the appellant in that respect, but that, in my respectful submission, sets out the basis upon which the Secretary of State approaches the penalty scheme vis-à-vis owner-hirers, that is the hauliers, the employer of the driver, as against the driver, who is not an appellant in this case.
That's not the basis the penalty was imposed, then, was it?
It's not, but, well, forgive me, is my lord referring to the basis at first instance, or the basis upon which the learned judge imposed the penalty?
I'm looking at the basis that's set out in the notice of liability. I mean, the basis of the notice of liability is 2E2.
Yes.
And that is the owner's obligation.
Everything else, the owner was exonerated. That's the right word.
Well, two points, if I may, for two comments. The first, 2E2, deals with, well, I say it's not a clear regulation, but it deals with both the responsibilities of the owner and adds responsibilities with respect to the driver, depending on which subparagraph you look at. But in any event, the rest of the notice exonerates, as my lord says, exonerates the appellant vis-à-vis that which he ought to have done.
2E2 is the owner or hirer.
Yes.
2E3 is the driver.
Yes, and as my lord says, the owner is exonerated on
the notice.
On the notice.
I suspect we need to get into the detail of the regulations. I mean,
Yes.
I'm not for a moment going to try to work out particular regulations, but suppose you have a duty to carry out a particular type of check and a duty to record that you have carried out the check. Now, supposing that you do as you're supposed to and you carry out the check, then you're not in breach of that requirement. But if you don't record it, you're still in breach of that requirement. So to say you're exonerated on all these other grounds doesn't of itself answer the question. You have to work out what it is that you were supposed to record and are alleged not to have recorded.
That, I'm afraid, is to get into the detail
Yes.
of the regulation itself, because I hope I can say this safely in this court, it's not the best drafted legislation we've ever seen. And so it leads to ambiguity and a perfect example, and uncertainty, and a perfect example of that I say ambiguity and uncertainty, is when you arrive at the position where the regulation requires the owner-hirer to make a record as soon as is practicable after the check has been made.
Oh, well, the word is afterwards.
Yes, but
So you're going to have to tell us what the word afterwards means.
Well, my lord has it. When is afterwards? Because if the check ought to be made, for instance, at the entrance to, I don't know, the United Kingdom control zone at Calais, it can only be made by the person making the check, the driver, because the owner-hirer is 10, 20, 30, 100, 150 miles away.
Not right, is it? It has to be made. It has to be made. The record has to be made by the owner.
That's one of the primary difficulties with the
And the only
legislation.
person representing the owner there is the driver.
I would take issue with respect with the proposition that the driver is representing the owner. The driver is an employee of the owner. The owner provides the driver with a document. There's lots of reference to checklists. The checklist isn't required. What's required is a record must be made. And checklist, I suppose, is a useful shorthand. The owner hirer provides the driver with a document which he is required to complete as and when he makes his checks. Is that a check and a record made by the employer through the actions of the driver? If it is, well then fine, but if it's not, because the driver fails to do so for whatever reason, and in this case for fraudulent purposes, the question then becomes, is the owner-hirer vicariously liable, as is suggested, for their driver's failure to do that which he ought to do?
Well, can I suggest, I think we really have to put aside the concept of vicarious liability, because the subsection imposes an obligation directly on the owner to make a record.
It does.
And the liability under that subsection is that of the owner. There's nothing vicarious about it. Now, there may be a question of by whom that obligation should be performed, but the owner is under an obligation to do it, so the owner has got to make arrangements for that record to be made.
Yes.
So that's the only issue, it seems to me. And what's not clear to me at the moment is what is it that is being said the owner did not do within 2E2?
Well, that's it. With respect,
You can tell me your case as to what is being said.
yes. With respect, that's a question for my learned friend, because we say we did do all that was required of us. And when it comes to the issue, did the owner-hirer make the relevant note or record as soon as is practicable afterwards? If his driver makes that record or fails to make that record, should the owner-hirer, upon learning of his driver's failure, make the record himself? Or is he entitled to provide his driver, to satisfy his duty, with a document and say to him, complete this document, and if you complete this document, we're all compliant?
Well, the owner can give him the document, but it's the owner's obligation to make the record
Well then, forgive me, my lord, but the question is, how does he if he's 500 miles away?
through his driver.
Well, but if his driver...
How else can he do it?
Well, that is why we complain.
How do we interpret this? How do we interpret the subsection?
My lord has it. That is why we complain that this subsection is uncertain and ambiguous.
I think we're going to have to allow you to get back to the beginning a bit, but just before we do that, for clarity, the version that the driver provided to your client is it at page 135 in the supplemental bundle?
It's a fraud.
No, quite, but had the driver been doing everything that he was supposed to do, then this is what would have
Pretty
been
much it's what it
done.
would have looked like. It's a pro forma, very usefully put up on the Home Office website by Border Force,
Yep.
because it, forgive me, ticks the boxes that need to be ticked.
Have we got the version that the driver provided, or was taken from the driver?
Yes.
Where do I find that?
Supplementary to.
Supplementary to.
Or is that 273?
273.
So, presumably on the Secretary of State's case, what the employer did not do, we'll leave aside for a moment the legal questions, is record. Is it at 137 stops 7 and 8, and possibly the final check?
Yes.
Yes, I see. So the Secretary of State has to say there was a breach of 2E2 because the owner did not record as soon as practicable after these checks. The checks that, according to the driver, were carried out as stops 7 and 8.
Yes, sir.
And probably it's better deferring this, but I would like to understand at some point, what checks those were in terms of the regulations. Are those standard checks?
They're always the standard checks.
And in terms of the regulation, so if we look at the amended regulation,
Well, I don't know if it's of any help, but at tab 5 of the authorities bundle,
we get the
Produced
current version,
documents.
which is very helpful.
thank you.
Now, I can see at 2C2, page 61, that it says the driver must perform the standard check every time the vehicle is parked.
That's, I'm going to come back to it, but that's another problem.
But that's not an owner obligation.
No.
So if we look at 2E2 for a moment, leaving aside your point about vicarious liability and so on, that says that as soon as practicable afterwards, and we'll assume at least for the moment that means as soon as practicable after you've done the thing, the owner must record in writing that they've ensured that actions set out in 2B2, 3, 5, 6 and 7 and 2C3 have been taken. So if we look at the actions recorded in the, you say, fraudulent vehicle checklist at stops 7, 8 and final check, are any of those things that were required by 2B2, 3, 5, 6, 7 and 2C3
Yes.
being, which ones are they?
All of them. The whole function of 2B2, 3, 5, 6 and 7 set out what a driver must do whilst he's en route to his journey.
Yes, I see.
And the obligation under 2E2 is upon the owner hirer to ensure that the driver has taken those steps.
So can we just look at it for a moment so I understand? If we look at 2B2, and that says before a journey, the owner must ensure that each seal used is distinguished and so on.
Yeah.
Was that something that was required to be performed at stop 7?
No, that's before the journey.
So,
There's no suggestion you were in breach in relation to that.
but of course, it's not the doing the thing; it's the recording of the thing.
Yeah, well, Malone Fringe suggests there is a suggestion, but we say there isn't. And my lord went to the notice of liability, and the notice of liability says we weren't in breach of that.
So, just pressing on for a moment, 2B3, that's before the vehicle begins any journey.
Yes.
So that's not something you would have to record at stop 7 or stop 8 on your
No.
case. So then 2B5, where the goods vehicle has a means of entry, the owner must before a journey. So that's again before a journey. So you say that doesn't apply at stop 7, stop 8 or
Correct.
at the end. 6. So where the goods vehicle has a cargo, the owner must take all reasonable steps to ensure that the cargo is able to be secured.
That doesn't necessarily always apply. The reference to the language secured by an optimal method, where it's not able to be secured by an optimal method. A very obvious example of that would be a load on a low loader trailer covered by a tarpaulin, which we see
Yes,
going
I see.
on. It's referring to that situation rather than boxes which can be locked and sealed.
So if we just relate this for a moment to 2E2, where you have to record that you've taken an action, it isn't suggested you didn't take an action if required, but if you did take it, you were presumably supposed to record it.
Yes.
So is this an action that would have been required to be taken at stop 7, stop 8?
No.
Because
It's a duty.
it's before a journey.
It's before the journey.
And 7 before a journey. So you're saying, well, that can't apply at stop 7 or stop 8.
Just so.
So that would leave 2C3. So that's whereas at any point during a journey, before you enter the United Kingdom, you know or have reason to believe that a means of entry has been opened. Well, that's not suggested, is it? So, leaving aside points on vicarious liability and the like, I'm immediately clear which action it is said that the owner didn't record.
Well, we say we recorded all of them, and in the notice of liability, the Secretary of State says we recorded all of them. Therefore, we say we were compliant with 2E2.
Yes, I see.
Forgive me, I don't understand the last point, because they say that you didn't comply with 2E2.
Well, blanket-wise, because 2E2 also refers to failing to record when the standard
This is
checks
where-
were made.
Come back to the question I asked, and I think having gone through my Lord's questions, maybe you say I don't know, but what is it said that you have failed to record, the owner has failed to record, that it was obliged to under 2E2?
Well, frankly, my lord, I don't know, because it's certainly not clear from the documents, the notice of liability, which have been provided by my learned friend, which suggests we have complied with those requirements which are placed upon us.
The documents show that you complied with the earlier regulations. It doesn't show that you recorded that you had complied with them.
Well, we did, and it's my learned friend to say why he says we didn't.
Exactly. But you're the appellant.
Yes.
So are you? If you say if your answer is I just don't understand it, I don't know.
I don't. That's why we're here.
That's the
Because
end of-
I
that's the end
don't
of the appeal,
understand
isn't it?
the basis upon which we have been penalised, where in the same breath, on the rest of the notice of liability, it says we've done that which we ought to have done.
Is the
I
phrase?
take the point about, forgive me, I see my lord wincing. I take the,
I'm sorry.
I take the
Wasn't
point-
necessarily your submissions that were making me wince.
Perhaps they were.
Yeah.
I take the point about the distinction to be drawn between whether or not they did something and whether or not they made a record of that something. And that is, I suspect, where my lord is going. In terms of the did something, yes, they did everything they were required to do. The complaint is we failed to make a record. We didn't fail to make a record because the checklist demonstrates, the earlier checklist demonstrates that all of that was done, and no complaint has been levelled against us that we didn't do that which we ought to have done, including record keeping, which is why I don't understand. I see my own friend shaking his head vigorously. Well, that's for him. But I don't understand.
So
Why we
sorry for interrupting you. It follows from that, doesn't it, that you could be liable for not recording that you've done an action under 2E2 if you haven't done the action.
Yes.
But if you're not required to do the action, then the liability under 2E2 can't arise. That's your point.
I would hope so, yes.
Can I ask you the question you thought I was wincing?
No, it wasn't you, my lord. It was.
I was being accused of wincing.
Oh, I think we were both wincing at the same time. We couldn't see each other wincing.
Well, then it must be me.
Is the phrase person responsible defined anywhere?
Well,
Respond.
Again,
Because
this is the difficulty with the drafting of the legislation. There is a definition of a responsible
there is,
person.
but that's not.
There is no definition of the person responsible.
No, and that the phrase "person responsible" appears in the statute
Yes.
in 31A1 on page. It's on page 2 of the. That's
Yes,
not-
the statute defines it. Yes.
Well, no, it doesn't define person responsible.
No, it doesn't. Forgive me.
Responsible person. A responsible person is the person responsible for the clandestine individual.
Well, it's either the owner hire, or the driver, or the or something else, a train driver or something, but it's a train vehicle. But yes, it's very clearly defined in the legislation.
Because the phrase "person responsible," as I say, appears in forget responsible person. Person responsible, undefined in the statute, you say,
Yes.
appears in 31A2, and again appears in 2E.
Yes.
The actions to be taken by a person responsible for a goods vehicle. And your interpretation, that depends. It can either be the owner or the driver,
Depending on context.
depending on context. And your case is that the obligations imposed by the previous regulations, 2B, 2C, etc., make it clear in each case in which case the person responsible is the owner.
Yes.
And for the reasons you've said, you say that in this case there is no liability. But is it possible? I mean, my lord objects to the phrase vicarious liability, and you've got that point.
Yeah.
Not so much vicarious liability for the fault of a driver, but the question is there a combined obligation under the regulations on the owner through the driver, which is not quite the same thing as vicarious liability.
I understand that. I too object to that phrase because I say you can't import any concepts of various liability into this type of regime. But it was a concept raised below by my learned friend. But in terms of there are two answers to that question. The first is that the regulations themselves refer separately to owner hirers and then to drivers, and therefore place separate responsibilities on each. My lord's just been through some of those. And secondly, in terms of the overall scheme, the owner hirer is treated separately vis-a-vis whether or not a penalty ought to be imposed from the driver. It's entirely possible within this scheme, not least because it's a discretionary scheme, for there to be a penalty imposed against a driver only and not against an owner hirer. And I've seen that happen. And I've produced a report of the senior designated judge
So Judge Kerr's decision.
at the same court.
She reached a different.
But she took a completely different view to the same point. A view you would be unsurprised to learn I would press upon, my lords. But that provides us with the very difficult answers of the question.
I'm just wondering whether that phrase "a person responsible" might in some way bring an owner not vicarious liable, but mean that the owner is responsible because they act through the driver.
A collective. Yes.
I'm not expressing it very well, but
because
person responsible isn't defined. Does that option?
I would suggest it's stretching the language a bit. I rather suspect that what's actually happened, and this is only my own suspicion, is that somebody's got the language the wrong way around in several places, and they might be referring to responsible persons. That's, I suppose, the more obvious solution. But my second argument against my lord's proposition of collective responsibility is if it were collective responsibility, then you would have what the old scheme had, which effectively said there must be an effective system of prevention in operation on the relevant occasion, and that provides you with your collective
It feels a
responsibility.
bit counterintuitive that the laws in the current climate has been tightened in a way which in fact loosens it.
Just so, here in this legislation, you see a separating out of the responsibilities of the owner hirer on the one hand and the driver on the other, and that I submit militates against my lord's proposition of a.
As I say, it feels counterintuitive as to what.
Exactly.
I mean, surely these rules are designed to tighten liability, aren't
I would urge the earlier
they? Okay.
mistaken use of language approach.
So,
Sorry.
well, what I was going to say, my lord could say otherwise in a moment. I mean, in terms of the factual story, I think we essentially has a factual story, and you've just helped us to identify the fully completed checklist and the inadequately completed checklist. We probably don't need any more about the facts particularly, do we?
No, I agree. And I would urge this additional point upon the Lords on that topic. To a degree, I submit that the fraudulent aspect of this case is, as Malone Friend says in his own skeleton argument, a bit of a red herring.
Yes.
The real issue is fraud or no fraud, as I opened it at the beginning, is whether or not the owner-hirer should be, all things being equal, liable for the misconduct or error or omission of his driver.
I follow that. So in that context, I know we've been jumping around already in the legislation. Would it be best if you took us through the bits of the legislation you think we should see
May I?
before you develop your submissions?
Thank you. When I was opening, I had almost finished the brief opening remarks, and I would like just to add one further remark, which may or may not be on point and may or may not cause winces, but I'd like to say it anyway. Understanding that we've already disposed of the propositions of vicarious liability and agency, and I would have submitted that they have no place in any regulatory scheme such as this. But I would add this, and I add it because of my Lord's comment about the sort of collective responsibility. And we would argue that, by analogy, why should the owner-hirer who has done all that which he ought to do be liable for a penalty in these circumstances when an owner-hirer under perhaps similar regimes would not be so? An owner-hirer is not responsible for his driver's speeding tickets. He's not responsible for his driver's parking transgressions. He's not, forgive me, vicariously liable for any infringements against the driver's hours and rest breaks regulations, which are extremely strong regulations and carry severe penalties, as do these regulations.
What about smuggling?
Smuggling is, I took my Lord's point, it's a slightly different point, because in smuggling the regime allows for the restoration of a vehicle which has been taken because they found too many cigarettes or more drugs than somebody ought to have had. But the regime permits the restoration of the vehicle with or without penalty, depending upon the culpability of the owner-hirer of the vehicle. And one of the tests that is employed by HM Revenue and Customs and Border Force when dealing with restoration is to ask the question, has the owner-hirer taken reasonable steps to prevent smuggling activities on the part of either his consignors or consignees or his driver? And the checks that are expected to be made with respect of the driver are to conduct proper interviews, to conduct proper background checks, including criminal background checks, and to ensure that the driver has a proper history. And if you are able to satisfy Revenue and Customs as an owner of a vehicle that you have carried out such checks, then in almost every case the vehicle will be restored to you for no penalty. So with respect to my learned friend's point, why no penalty there, but a penalty here in what might be described as analogous circumstances? I was going to conduct a legislative overview, but you're, I think.
Well, actually, I think it would help us if you took us through the bits that you think matter.
Well, we start then with the Immigration and Asylum Act 1999, which introduced the forerunner to this scheme, and in particular Section 32.2, which provided that the Secretary of State may, at their leisure or discretion, impose a penalty in breach of the scheme. One of the things that Act did not provide for was a route of appeal to any court or tribunal. What the Act did was it provided for a notice of objection route, but nothing more. And so in due course, in 2002, this court considered that many aspects of the case, but that in particular in International Trust Transport, Ross, GmbH and others, cited at 2002 EWCA Civ 158. I don't take you to the report itself. It's simply noteworthy that following that decision, Parliament inserted the section 35A.
So at that stage, this court said that there was a failure to comply with the convention.
It did. In part because of the inability to appeal beyond the Secretary of State by notice of objection. And so that gave rise to section 35A. And the carrier's liability regulations, which followed on. It's worth noting that those regulations dealt with a number of ancillary matters, but imposed maximum penalties of £2,000 per clandestine entrant per responsible person, with an aggregate maximum of £4,000 per penalty. And so whilst one clandestine entrant might result in a maximum of £4,000, 10 would result in a maximum of £40,000, so to speak. And the next notable event after that occurred when this court heard the appeal of Boller Transport BV and the Secretary of State in 2016 at EWCA Civ 783. There the court confirmed the process by which the county short should approach a section 35A appeal, and it's quoted in my skeleton argument. I won't go into it now. But perhaps interestingly affirmed what Mr. Justice Sales was then said in a decision of the Queen's Bench Division to the effect the purpose of the 1999 Act scheme was to place the burden of combating clandestine entrants on the haulage industry and to, quote, encourage carriers not to transport clandestine entrants and to exercise care to ensure that there are no clandestine entrant stowaways in their vehicles. So it's designed not to penalise, although there is a penalty element. It's designed to encourage hauliers, with respect to hauliers, to do that which they really ought to do in any event. There then followed in 2021 the appeal of Link Spolker and others and the Secretary of State. In that case, a number of observations were made by Lord Justice Stuart Smith. We would submit in due course carry over to this appeal, in certain principles at least, including affirming the decision in Bolly as to both the existence of the discretion and the way in which the county court ought to approach its task. What's of note was that the court in Link Spolker disapproved of the way in which the respondent applied parts of the then scheme, particularly when considering whether or not a responsible person had made out the then statutory section 34(3) defence. The cynic in me suggests that the Parliament's answer to that appeal was the Nationality and Borders Act 2022, because that act repealed the section 34(3) defence in its entirety. So no effective system of prevention in operation on the occasion in question, and replaced it with the statutory scheme that we are dealing with today. Section 42 of the 2002 Act inserted into the 1999 Act, Section 31A, which provided for the imposition of a completely new penalty, not the subject of this appeal, to deal with situations where vehicles with no clandestine entrance discovered therein were nevertheless not secure. Schedule 5 and paragraph 4.2 of the 2002 Act.
Sorry, Schedule 5.
Schedule 5, paragraph 4 brackets 2.
Let me just find
the 2022 Act.
Oh, I see, the 2022 Act.
Which is behind tab 3.
We don't have tabs.
And,
Yes, I see.
it's the authorities bundle that it's highlighted in yellow, I think. I handed up to, a few days ago, we sent in some hard copies.
We've got, Lord and I, Or
Oh, are they sorry, in which case, page 61, sorry. They should have been tabbed. 61.
I seem to be rarely privileged. I have an authorities bundle. So that's Schedule 5 to the 2022 Act.
Yes, and that's what I've condensed down into my own document, which I took you to earlier, which is, I think, if you have tabs, it's tab 5, but it starts at page 58.
So when you say you condense this down into your own document,
Well, I've taken the 2002 regulations, applied the amendments as set out in the 2022 schedule,
yes.
so that we have a discrete document which effectively sets out.
So this is not something that is generally available. It's
I send it to every court I appear in front of, but other than that, I know it's been pinched by my opponents a couple of times,
yes.
but other than that, it's not. The only alternative is to wade your way through the Schedule 5 and apply it to the 2002 regulations to identify the changes. I just find this a useful aid memoir,
Yes.
and I thought the court might find it to be so as well. So that's where we arrive at. I would note that one of the important points about this act is it altered the level of penalties. The 2022 Act imposed a maximum penalty now of £10,000 per clandestine entrant per responsible person. And we now see, for very obvious reasons, penalties being imposed under the joint and several liability principle of £100,000 to £300,000, which is a marked shift in what went before.
Can I just take you back to the point I was making about the definition of person responsible? I think I was wrong, actually. I think if you look at 31A, please tell me, Mr. Clark, if I'm barking up the wrong tree or in the wrong section. But 31A 14 on page 4 of my says, for the purposes of this section, the persons responsible for a goods vehicle are, if it's attached trailer, owner, hirer and operator, and if it is not, owner, hirer and driver. So does that carry over?
No.
It doesn't.
And the reason I say it doesn't is because you will recall just now I alluded to a new penalty being introduced in relation to vehicles which arrived at a border with no clandestine entrance in, but which were insecure. That is the penalty regime set out in section 31A.
Where is that in the bundle?
Well, section 31A is the section my lord
Yes.
just referred to.
Well, that's what sorry, I'm being slow, I'm sure. 31A, that defines persons responsible.
Well, 31A is penalty for failure to secure a goods vehicle.
Okay.
That is not the section we are operating under. We are operating under section 32.
and there you find, as I think you were saying, 32.2, the Secretary may require a person who is responsible for a clandestine entrant,
Yes.
as opposed to a vehicle.
Yes. And so distinguishing between just a person, as my lord says, just in the situation where there are no clandestine entrants. In section 32.5, at page 5, the bottom, in the case of a clandestine entrant to subsection 1,
Yes, but all the regulations on 61, 62, etc., talk about the persons responsible for a goods vehicle.
yeah.
For the purposes of 31A1.
Not us.
You need to look at 32.6.
That relates to what's colloquially known as a loose shunted trailer. So that's a trailer which arrives at the harbour by a truck in Europe and then is loaded onto the ferry, not by a truck driver pulling the trailer with his cab, but by the ferry company, and is offloaded in the same way. So there is no driver in relation to that.
That's 6A. You've got 6B.
Penalty may not be imposed on a person under subsection 2 if penalty is imposed on that person under section 31A1 in respect of the same circumstances.
You have in mind 6 little b as opposed to 6 capital B, I think.
Ah,
So I think that what my lord is referring to is in the case of a clandestine entrant to whom subsection 1B or C applies, each of the following is a responsible person. And then little b, if the owner, hirer and driver of the vehicle.
Each of the following is a responsible person:
yes.
owner and driver. So they're both responsible persons under, and that is the same as under the previous.
It is. That's always been my understanding of the position. The difficulty, as my lord identifies, is that the words are transposed in section paragraph 2E2 of the regulations, so that they become a person responsible for. And the question is, does that mean the same thing?
But that's not the focus of your case.
It's not.
No.
But doesn't that provide a clue that both the owner and the driver might be responsible?
It might, except that we go back to an earlier submission I made, which to the effect that under the 2023 regulations, if I can call them that, each has their own responsibilities. There is a clear definition between the two, and they only come together where there is a contextual basis for them to do so. It's as we said earlier, in the context of a driver making his standard checks whilst he's en route, he must be the responsible person rather than the owner-hirer being the responsible person because the owner-hirer is 500 miles away or wherever.
It's even clearer because the particular actions referred to in 2E2 identify who it is who's advised to take them.
Yes.
Just before we come to the regulations, in terms of the Act, so 32A says the Secretary of State has to issue a code of practice and have regard to the code of practice. And then in terms of the appeal procedure, section 35A, it's a rehearing before the judge, that the judge has to have regard to the code of practice and anything else that the court thinks relevant.
Yes. Thank you.
Anything else we need from the Act?
From the Act, I suggest not, but then we, I think, get into the regulations themselves.
Yes.
Can I say this, rather than trawl you through my skeleton argument? You have it, you have read it, you will read
Yes.
it again. It's part of my case. But dealing with the regulations themselves, I suggest respectfully my tab 5 document might be the easiest way
Yes.
of dealing with things. Paragraph 2 deals with a number of interpretations. Responsible person, we see third one up from the bottom, means a person responsible for a clandestine entrant under section 32 of the Act. So there it adopts the statutory formulation, that's I suppose the pre-transposition formulation. I don't think I need to take you to any of the other interpretive provisions. Paragraph 2A deals with section 31A, or refers back to section 31A of the Act, and therefore is not relevant for our purposes. That's the vehicle that arrives which is unsecured but without clandestine entrance in. 2B2 is the first regulation which bites for our purposes.
Just so I'm on the right physical page, I'm on looking at page 60 in the bundle.
Yes.
2B2.
Yes. So 2B.
2B.
Yes. I'm desperately resisting the obvious pun. For the purposes of 2B1, for the purposes of section 31A1 again, we are referring to the earlier scheme.
Yeah.
Ditto 2C.
So just pausing at 2B at the moment. That imposes certain obligations on the owner and also the
Yes.
driver. So if we take, say, 2B2, before a journey, the owner must ensure that each seal is distinguished. And then 2B3, the owner must ensure that the cable or strap is in good working order, and so on.
Yes.
Now, the owner will typically be a limited liability company, presumably.
Often, but not always.
Not, at any rate, can be.
Yes.
It could be an owner driver.
It
Could
could
be
be,
an
and there are quite a few unincorporated companies.
But at any rate, it can be a
Yes.
company. And then, plainly, the company can only act through humans.
Yes.
You would expect some representative of the owner to be doing these things.
Yes.
In a sense, it doesn't matter because the owner must insure.
Yes.
Yes. Rather reinforces my lord's point, I think. Yes.
One can, as we go through it, pick up that 2B2 is the owner, and it appears in the list of things in 2E2.
Yes.
And as you go through, you see that. So 2B4, for example, the driver,
Yes.
therefore only appears in 2E3.
Yes. And with respect, my lord makes the point I seek to make, which is by and large the regulations seek to distinguish the responsibilities between the two.
Well, the only exception to that is 7,
Yes.
where 7 says the driver and either the owner or hirer. That's both.
Well, in that regulation, yes, but later on we start getting into the person responsible.
So can we just...
And that provides us with a degree of difficulty, because the person responsible will be the person who at the time in question is the person on the scene, which more often than not will be the driver if he's en route.
So can we just look at 2B7 for a moment? Before the journey begins, we suppose that the driver looks at whether things are in working order and finds out that they're not.
Yes.
Now, he's then in breach. But the owner is in breach too?
Well, yes. So that must be the position, because the requirement requires the driver and either the owner or hirer. But of course, he wouldn't be in breach if the owner then remedied the position, which I rather suspect is the point of that particular sub-regulation. The owner discovers that there's a lock missing and provides a new one.
Is it also important to note that each of these obligations relates to before the journey?
Yes.
So insofar as we're looking at those listed in 2E2, all of them are obligations of the owner. The 2B obligations are obligations of the owner, and
Yes.
they are all before the journey.
Yes. And 2B8 over the page at 61 places the direct responsibility onto the driver for what occurs en route.
Hence why that appears in 3.
Yes. But then we go to 2C. And it's 2C2 again. This is the driver. 2C3. And here we start becoming somewhat ambiguous. But the contextual point I made, where at any point during the journey, before the goods vehicle enters the United Kingdom, a person responsible for the goods vehicle. Well, who is that?
Well, that can
rhetorical question.
That could be the owner as well as the driver, depending
could
on the
be.
circumstances.
Well, except we are at any point during the journey, so we're on the road now.
And it only arises if they know or have reason to believe.
Yeah.
So it could be the owner, but as a matter of fact, it's more likely to be the driver.
Yes, but then who is the duty placed upon if the driver identifies a problem because he's on the scene and he sees, I don't know, a hole in the side of his vehicle, which the owner is ignorant of? Who is the duty placed upon?
Or to put it another way, bringing out a point you were making earlier, if the driver knows and the driver is employed by the owner, does the driver's knowledge get attributed to the owner so that the owner knows as well?
Just so.
Well, there's no reason why an employee's knowledge would be attributed, is there?
I'm sorry?
There's no reason why an employee's knowledge would necessarily be attributed to a limited company.
Well, if that's correct, then I hate to fast forward the whole process. Why should a driver's knowledge that he hadn't done that which he ought to have done be attributed to the company such that the company ends up paying a penalty when they've done all that
It's
they ought
basically
to have
company
done?
law, isn't it? I mean, you have to
Well, yes, which is why I...
directing mind of the company. I mean, for example, you might have an owner-driver whereby both the owner and the driver is going to know,
Yes,
by definition.
yes. A hole in the side of the vehicle before it leaves. But as an obvious example, yes.
Generally, as a matter of, I don't know if it's controversial, generally as a matter of basic company law, you wouldn't attribute the knowledge of an employee to a company.
Well, with respect, my lord, is that not the nub of my appeal?
Well, can I say again, I keep coming back to it, what I don't understand at the moment, I dare say will be helped in due course, is what is the allegation against your
Yes.
client? What is it you're alleged not to have recorded
Yes.
that you should have recorded? Doesn't appear on the notice of penalty,
No.
and
And it ought to.
you don't seem to be able to tell us.
Well, this is because I'm sorry, but it's because I don't know, my lord. We didn't know below either.
It's extraordinary it's got through so many stages without that being identified.
You don't think?
It's actually helpful to carry on going through these.
Yeah, well, I hope
we
that
paused at 2C, but
Yeah,
the point my lord is making, I think, is illustrated if we carry on
yes.
the distinction. So 2D, a person responsible, which I would suggest can be the owner or the driver, who knows or has reasonable cause to suspect that a relevant event has occurred, that being unauthorised access,
Must take steps.
must take steps.
Yes.
Now, that would, in all probability, be the driver. If the driver told the owner, then the owner would be liable under an obligation. But unless there's some other reason why the owner should be attributed with knowledge, you would say the owner's in the
Doesn't
clear.
have knowledge. But I would turn it round the other way. If the driver doesn't tell the owner and he doesn't tell the authorities, that is, he doesn't comply with this particular duty, again, the owner would be none the wiser. And so how do you, I rhetorically ask, attribute liability to the owner for the driver's failure to act as he should?
But that isn't recorded with, that isn't expressly referred to in the record keeping section.
It comes later on. There are other regulations later on that deal with requirements to notify.
Yeah, but forgive me, it doesn't come within that which we're looking at.
It doesn't. No, forgive me. It does in a sense. I think that if you go to
Does it become relevant through regulation 3A?
yes,
But going on through 2D, 2D, we now get what the responsible person gets an initial P.
I'm sorry.
The responsible person is given an initial P.
Yes.
P arises quite a lot of litigation in different legislation in different contexts.
Yes.
But here, P is the responsible person, and in 2D4, at the earliest opportunity upon arrival at immigration control.
Forgive me for dancing on a pinhead, but P is not a responsible person.
Well, that's how it's P is a person. P is defined as a person responsible.
Person responsible.
for the goods
It's-
vehicle.
It's the
Yeah, but that's what we're looking.
yeah.
All of these provisions are couched as being for the purposes of 31A 1B.
They are.
That's how it's couched.
Which is why there's a separate argument that goes they don't bite on in this case in any event.
Yes,
That's a matter for my lords.
but any rate, so for the rest of 2D 4, 5, 6, that's all about the driver. 5
It is.
but P must not take the vehicle to a relevant place. So
That can only be the
that
driver.
can only be the driver. Can't it?
And therein again it lies the dilemma. If under 2D2 a person responsible for the goods vehicle is P, and then the rest of 2D talks about P being the driver, is the person responsible elsewhere in the regulations, such as under 2E, the owner hirer?
Well, sometimes it depends. Sometimes it is, sometimes it isn't.
That is
But all these provisions, I know if I'm barking at the wrong tree, forgive me, but they are all for the purposes of section 31A,
Yeah.
not 32.
But we do get all this brought in for purposes of 32 by regulation 3A. In a sense.
forgive me, I'm looking at regulation 3.
It's 3 capital A. So for the purposes of section 32 2C, to be eligible for a reduction under section 32 2, you have to take in all the actions that you were required to take under regulations 2B, 2C, 2D, and 2E. So compliance with 2E is relevant specifically because that affects your eligibility for the reduction under 32 2. Yeah.
That's a separate ground of appeal, which I'm going to deal with in due course, about whether a reduction is sufficient.
Yes.
Or indeed consistent with the primary legislation. But having done that, we then come to regulation 2E. And it's 2E2. And with respect, my lords, we've been through 2E2A already and identified what I would describe as the difficulties with that. But what we haven't done with respect is touched upon the wording, the opening words of 2E2, as soon as practicable afterwards. The owner must record in writing that they have ensured the actions set out in regulation, etc., and any fines noted. And so that begs the question, what does as soon as practicable afterwards mean? If we're talking about those regulations which apply pre-commencement of journey, then that's a relatively simple task. And as I understand it, there appears to be no complaint. Certainly there was no complaint below that my clients had failed to do the pre-journey, satisfy the pre-journey requirements.
Can I put a proposition to you that afterwards must mean after the action, or may mean after the action, whatever it is. So if you look at,
I think it must be.
yeah, so it depends. In each case, the action referred to in the regulation,
Yeah.
there's an obligation under E to record it as soon as practicable after that.
So just to be clear, I mean, this is, I think, how I've read it too. You might think there's an ambiguity as to whether it's saying as soon as practicable after the journey, or as soon as practicable after you should have done the action. And I think you're saying, well, it must mean as soon as practicable after the action, and that's how I've read it.
Yeah, in a different appeal, His Honour Judge Godsmark Casey, the former designated civil judge at Nottingham, in a different case drew an interesting, or raised an interesting rhetorical question on that point to this effect. If a driver arrives at the UK control zone and fails to conduct his final check and goes through and is discovered to have clandestine entrants, at what point does the owner hire? Is the owner hire required to make his record? He can make no record that a check was made because no check was made. But in his ignorance, he doesn't learn of the difficulty until, I don't know, a day after. And the day after, the owner hirer then makes a record that the check was not made. Is the owner hirer in breach?
I find it a bit hard to see that as a breach of 2E. So your obligation is to record what you have insured, and if you haven't insured it, I can't see how you can record it.
And then you go back to the question, as the owner hirer, how do you insure it?
Yes.
So to what extent must you enforce your will upon the driver? To what extent are you entitled to trust your driver?
There is no obligation on the owner to record a final check.
No. But it was an example given by His Honour Judge Godsmark Casey. The point is about when you must. I think there is.
Forgive me, I think this is really fundamental. I just don't think the issue arises because the structure of this doesn't impose an obligation on the owner to do something that isn't in their control.
I would respectfully agree with that proposition.
I mean, the structure is the owner has to record all the matters they're obliged to insure before they send the driver off.
Yeah.
Before they send the driver off, they've got to do these things,
Yes.
and they must record that they've done them.
Yes.
And that's 2B, 2, 3, 4, 6, and 7. And then, if they come to know something during the journey, they must record it under 2C3. Otherwise, the obligations are on the driver, and he must record them.
So what have I done wrong?
What have you done wrong?
We're back to the.
Yes, absolutely.
Yeah.
That's your case.
It is.
And at the moment, I'm not understanding, I keep saying it, at some point we'll come back to it, what is alleged you have done wrong.
Yeah. And I'm in the same thought. But those are the regulations, I think.
And should we just notice 3A, to the extent we haven't already noticed 3A? Well, it might be relevant to notice 3A. So 3A says, well, you have to have done all these things to be eligible under 32.2. So should we just go back to the Act a moment?
Well, 32.2 is the imposition of a penalty.
Well, yes, but so just going back to section 32 a moment. 32.2 says the Secretary of State may impose a penalty. 32.2a says, well, you can't impose a penalty of more than the relevant amount. And then you have to have regard to the code of practice.
Yep.
So just pausing there, is it open to the Secretary of State to impose a penalty even where there has been no failure to comply with any of the regulations?
On the bare face of the legislation, yes. That's where the discretion comes in. And the complaint there may be, and I'm very aware of this is not a public law hearing, but the very question there is, to what extent should a discretion be exercised to either issue no penalty or to issue a penalty in a sum of 0?
Yes. And then, of course, the problem gets transferred to the county court on an appeal where it's a rehearing.
Yes.
And the judge is told he's to have regard to the code of practice and to anything else that he thinks relevant. But as a matter of basic law, you say, well, I'm not sure you say it, you sort of accept there is power to impose a penalty even though there has been compliance with all the regulations. But you say, well, you shouldn't anyway.
Well, I think it breaks down into 2 parts.
Yeah.
The first part is there is a discretion not to impose a penalty.
Yes.
That's implicit in the primary legislation. If I'm wrong about that, and a penalty must be imposed because the penalty regime is triggered for these purposes by the presence of clandestine entrants, if a penalty must be imposed, then again, there has to be the exercise of discretion. And to some extent, the code of practice allows for that exercise of discretion because it provides fixed reductions for complying with regulations, but B, it also provides, makes a provision which says, taking into account compliance with the regulations. I'll take you to it rather than paraphrasing.
It can't be an obligation to impose a penalty because it may.
Well, I say not, but the question was, must he? And I answered, no, he must not. But if the counter view be taken that he must, then he has a discretion to impose.
How it could be must impose a penalty when the wording is the Secretary of State may require a person.
Well, that's my position. But
I mean, the problem does get transferred to the judge on an appeal. So at that stage, on the face of it, the judge has power to impose a penalty, but he has to have regard to the code of practice. And the code of practice says that a discount will be applied if you're not the driver and you weren't present and you've acted to ensure compliance with the regulations.
Yeah.
Now, that might suggest that in circumstances where you've done everything in compliance with the regulations, but you've still got an entrant in your vehicle, you could expect to end up with a 50% penalty.
that, with respect, is where the must comes in, because the code of practice makes no provision for either for the exercise of a discretion right at the beginning to issue no penalty, or having issued a penalty to exercise a discretion to issue a 0 penalty. And if one goes to page 6 of the code, it's at page 77 of the bundle, which deals with the discounts. Just above the underlined words joint liability, the Secretary of State may also consider any other matters the Secretary of State thinks relevant.
And there's the same provision in the appeal provision for the judge taking into account anything he thinks relevant.
The difficulty we identify with the cast of the code of practice is that it makes no concession to the exercise of any discretion not to impose a penalty or to impose a 0 sum penalty. The entire code of practice is predicated towards the proposition that a maximum penalty is a starting point, and you can have discounts if you could comply with, if you're part of the accreditation scheme, which is not an element of this appeal. You can have discounts if you're a small or medium-sized business, or I say discounts, reductions, forgive me, and you can have other reductions as the Secretary of State sees fit within that sentence, which seems to import a sort of discretion, but you can't have a 0 penalty. That, in my respectful submission, must be wrong because it's inconsistent with the primary legislation.
Which makes everything discretionary.
Just so.
Once you decide to impose a penalty, the process does not, the structure is not that if you have complied with all the regulations, you are absolved from any liability.
No. It's you will have a penalty. And the only question is how much. Again, inconsistent with the exercise of a discretion. Because why should any citizen pay a penalty in circumstances where they have done everything which is required of them within the legislation? I know it's a separate argument, but it does feed in.
That is because their vehicle has been used to allow clandestine entrance.
Well, the rhetorical question there is, are they not as much the victim of a breach of the regulations as anybody else? If they've done everything that's required of them, they don't know their vehicle is being so used, they have done nothing wrong in law, yet they are to be penalised.
Well, the discretion would allow the court to take in, and the decision maker and the court to take into account all sorts of
It does,
criteria.
but it doesn't.
I mean, you can have degrees of blamelessness, is what I mean.
Another of my difficulties, which I was going to come on to, which is degrees of blameworthiness. Because again, whilst the Secretary of State may also consider any other matters the Secretary of State can take into account, and there's a sort of subliminal suggestion that a penalty can be reduced if the owner-hirer has complied with their share of the regulations, there's nothing to suggest that a degree of compliance might be relevant. So, for instance, if a owner-hirer had done, and this comes back to the pointed question, if it be demonstrated that we had done something wrong, but the Secretary of State concedes that we did everything we ought to have done pre-journey, but the only failing on our part was we did not ensure that the record was made at the end game. Well, how does the Secretary of State, how does the court at first instance account for that degree of culpability, which is very, very different from the degree of culpability which goes, well, I don't care what these regulations say, you take that load to England and what happens, happens.
Is the answer, or is it relevant to consider the order in which you consider the discretion, do you, before you consider the structured deductions in the regulations?
I would submit that the starting point is the primary legislation.
Yeah, okay. Well, the primary legislation puts you liable, isn't it?
Puts you
As a responsible, you are a responsible
puts you
person.
as a responsible person, and it provides a discretion.
Yeah, that's what I see what you mean.
And so, forgive me. I think the answer to my lord's
Discretion
question,
comes first.
discretion comes first.
Sorry?
Well, I think there are two discretions. Forgive me. Discretion comes first, whether or not to impose a penalty. The Secretary of State may. That's section 32(2). If the Secretary of State decides in the exercise of his discretion to impose a penalty, we then get to the level of the penalty, and there's a sort of implicit discretion in the code of practice which deals with level of penalty. I say it's missing some elements, but essentially that's it. So two discretions, or the exercise of discretion twice, however you want to put it.
Yeah. So you say the Secretary of State and the judge were wrong in thinking that there was a breach of regulation 2E2.
Yes.
If that's right, then on any view, the judge's decision would have to be revisited, I suppose.
Yes.
But it wouldn't necessarily follow from that conclusion that you were off the hook, because the legislation empowers the Secretary of State and the court to impose a penalty even where there has been compliance, and indeed the code of practice to which the Secretary of State and the court are required to have regard rather points to a 50% reduction rather than absolute absolution.
Wrongly, I say.
Yes.
But I'm afraid there's another unfortunate point therein as well, because the code of practice talks of a 50% reduction where one is a member of the accreditation scheme, and a 50% reduction will be applied to the starting point of the level of penalty if the responsible person is not the driver and was not present during the vehicle journey to the United Kingdom. That's generally the owner hirer. Is that a 25% penalty or is it a 100% reduction?
I slightly feel that we can dodge that problem in the sense you don't get the first 50% reduction, and where you don't get the first 50% reduction, presumably the second 50% reduction has to be a 50% reduction.
Well, yes, I see that, except that this was another problem that taxed her on a Judge Coe case, and I think jointly the bar is hoping to receive some guidance from this court. I'm sorry to make your work too much. Some guidance from this court as to how the lower courts ought to approach these issues in the future.
Just to be clear, in many instances, the fact that at the end of the day there was a clandestine entrant will have absolutely nothing to do with whether or not the regulations were complied with prior to departure.
Yes.
So one can see that in that context, compliance with the regulations on the part of the owner is in effect regarded as a mitigating factor. It is, look, you've complied with the regulations, but it actually has no real causative link with the fact that when the vehicle came through customs at some point on the journey, clandestine entrants had boarded. So in that context, one can see that the mere fact that you can show everything, T's were crossed and I's were dotted before the journey started doesn't get you off the hook for all £10,000 or £6,000.
I would respectfully disagree, my lord. It takes us back to a point that was considered by this court in International Transport Roth way back in 2002. I won't go to it, but because the point is trite. And effectively, what their lordship said in that case was that there is, and it was in relation to the old defence of an effective system of prevention in operation on the relevant occasion, where the court in that case said there is no such thing as a perfect system of prevention because of the determined nature of the clandestine entrance that we are dealing with. And therefore, if there is no such thing as a perfect system of prevention, then regardless of the steps the owner hirer takes to protect his vehicle, the fact that a clandestine entrant entered does not in any way militate against the proposition that the owner hirer had an effective system of prevention in place. That was the nub of what they said, this court said in Internet, and that must apply here as well, because if you take the view that doesn't matter what the owner haulier does in terms of securing his vehicle before the journey goes, that's not sufficient to protect the vehicle from clandestine entrance, then you're falling back on the International Transport Roth principle, that there is no perfect system. That's my first answer to my lord's point, but my second answer is this. What's happened here is that as Parliament has removed the need to consider whether or not a given system of prevention is adequate or not, or is effective or not, which in large part required the Secretary of State and the lower court and this court in the case of Link to ask the question in a sort of holistic way. Has this operator done that which they ought to do? Have they done the best they can? This new scheme removes that element entirely from the process. And what it does is it sets out a rules-based scheme, if you like, a black letter law scheme, which says these are the steps you must take. And if you take these steps, regardless of whether or not a clandestine entrance managed to get into your vehicle, if you take these steps, then we can, I would suggest, not issue a penalty, your section 32(2) discretion. And if we are to issue a penalty, we can mitigate that penalty according to our code of conduct and the exercise of the discretion. And so the fact that,
the code of conduct, it only gets you a 50%.
well, I say that's wrong, because there ought to be a discretion to allow and it is only a code of conduct. It's not binding.
But those regulations don't do anything to address the questions of what training
No,
or
all gone,
monitoring
all gone.
that the owner does in relation to the driver's performance of his.
Yes, it's all gone. Those were requirements under the old code of practice relating to the imposition of penalties, and Parliament saw fit to remove any reference to the need to train drivers, to repeat train them, to penalise them if they breach the regulations, etc.
Is the
My Lord, forgive me, please.
forgive me, I'm sorry.
No, no.
You carry on.
I'm most grateful. The point that my Lord makes about, well, whatever the owner-hirer has done pre-journey, that's all to nothing if a clandestine entrant gets in. I would submit is to impose a strict liability scheme, because if you must issue a penalty simply because a clandestine entrant has breached your security, then that does smack of strict liability.
It's a strict liability scheme.
It's not a strict liability scheme. It's a discretionary scheme. Section 32(2), the Secretary of State may impose a
What
penalty.
mean by strict liability is that there is no element of mens rea in the penalty. not that there may not be. There's always there may often be a discretion as to whether to impose a penalty. But strict liability means it's not dependent upon a guilty mind.
Well, does that not go back to the question posed earlier on, that is there a discretion imported in Section 32(2) at all?
Can I just sort of pick up the discretionary bit, and you refer to training, and of course the judge in his decision has regard to what he thinks about training.
Yeah.
Do you say it's wrong for either the Secretary of State or the judge to have regard to training in exercising the discretion, or would you accept that that's something that can be taken into account?
Again, I'm going to be bold here and submit this. This is a black letter law scheme which replaces what was otherwise a much more holistic and nebulous scheme. The holistic scheme, in part, made direct reference through the code of practice to the requirement to monitor the driver's conduct. What that actually meant was whether or not he completed his paperwork, etc. Trained the driver to follow the scheme, the scheme of prevention imposed by the employer, and various other matters. And Parliament, in its wisdom, chose to sweep that away. If Parliament, we must act with respect on the basis that Parliament knew what it was doing and intended to do what it did. And if Parliament chose to sweep all of that away for its own reasons, no doubt because Parliament thought that that scheme was then not effective enough, because it was too holistic, too nebulous perhaps, Parliament replaced it with what is a very formulaic black letter law regulation-based scheme.
Save that, both in the Code of Practice and in Section 35A, you're told that the decision maker can take into account other things that they think relevant.
Yeah.
And one might say, well, the degree of training is something that they might think relevant.
That's the second part to my answer, is that in terms of whether or not to impose a penalty, training, monitoring, etc., plays no role.
Can I ask the question I've been trying to ask?
Sorry.
I don't want to
It's
interrupt you.
disrespectful,
So when
I'm
you get to the end of a paragraph, if you've got, can I raise the question? What can you tell us about the accreditation scheme? What's that all about?
The accreditation scheme is a scheme operated by Border Force, which
By the Border Force.
Force,
Sorry, yes.
who are effectively the relevant
Yes,
authority
yes.
acting for the Secretary of State. The applicant for the accreditation scheme must demonstrate that they are compliant in many respects, that they comply with all of the regulations, that they. I think it requires a bit of training of drivers.
Well, I was going to ask, does that? When did the scheme come into effect?
Many years ago.
Okay. Does it include provisions about training, etc., the sort of things we've been talking about?
Yes, it does.
So under what you're calling the black letter scheme, and forgive me again if I've got the wrong
No,
stick.
that's
Under your interpretation, you get a 50% discount if you're in the accreditation scheme, and on your interpretation, 100% discount, another 50%, if in addition you do everything you're supposed to do, whatever the phrase is in the code. So that would, under your interpretation, that would get you off the hook completely if you got over those two hurdles, whether or not the Secretary of State had decided to apply the discretion at the earlier stage.
That may be right. I only hesitate because it's not under my interpretation. It's under Judge Coe's interpretation, which I don't necessarily adopt. And the reason I don't necessarily adopt it is simply this, because the accreditation scheme is voluntary. You are not required to be a member of the accreditation scheme when the Secretary of State is considering whether or not ab initio to impose a penalty. That aspect of the scheme only kicks in once it has been determined that a penalty shall be imposed.
Yes, but as my Lord's pointed out, there's a strict liability as a starting point. The starting point is if a clandestine individual comes in on your vehicle, you're liable. The question whether there should be a penalty is then determined first of all by the application of the discretion, and after that, the question is under your what you call the black letter interpretation. There's on your case, I think 100% discount.
Yes.
If you get over both of those hurdles. Now that, to my way of thinking, for the first time, I can see a logic in the way the structure might work.
But
even if it's because your complaint is that it's much more rigid because of the taking away of the other more flexible questions which were under the previous regime.
Well, yes, and ought to be under this regime. We're back to the fundamental complaint I keep crying, which goes, if he's done everything, why should he be penalised? What's a small side point? Forgive me, I took objection to my Lord's use of the term strict liability because what I misunderstood you to mean was strict liability per section 32. Well, in fact, I think now you meant that if an entrant is found in the vehicle, then strict liability, you are liable for a penalty, not you will have one. And if that was my misunderstanding, I apologise.
That's
Just to go back to the nature of how it works, my understanding is that the statute provides you may impose the penalty 42.2. And 2B says the Secretary of State may reduce the amount if they can show they took the action specified in regulations under 2C.
Yeah.
So that's may reduce the amount of the penalty. And then 2C says must specify in regulations the actions that a responsible person must have taken in order to be eligible for reduction. So that's the statute itself provides that it is a reduction,
Yes.
not an exculpation. And then the rules provide for it to be a reduction expressly in order to be 3A, in order to be eligible for a reduction. In the rules, in 3A, page 63. And then the Code of Conduct provides for it to be a reduction of 50%. So we have a complete unanimity from the statute to the rules, regulations, to the Code of Practice, that all you get if you comply with the regulations is a reduction.
Except that the Code of Practice also indicates that, quote, the Secretary of State may also consider any other matters.
Yes.
And therein again lies the discretion.
No, your submission to us, as I understand it, is when your client has done, quote, nothing wrong. In other words, it has complied with the regulations, it should not have any penalty.
Yes.
And what I am suggesting to you in response to that is directly contrary to the statute, the regulations, and the code, which expressly says all you get is a reduction.
Yes, I see that, but for that last sentence, which isn't about reductions at all. It's about what.
As far as what you get by virtue of compliance with the regulations, that is specified. You have to show that compliance to get a reduction.
Yes, I accept.
So what I'm saying is I don't see how you can parlay that into saying if we comply with the regulations, we don't get a penalty at all.
Again, I'm in favour of two responses. Two responses. The first is that that doesn't get away from that last line, that the Secretary of State may also consider any other matters the Secretary of State thinks relevant. That's the first point. But the second point is, whilst I don't disagree with the route that you've taken me through vis-à-vis the legislation and regulations, we still go back to the very starting point, which is whether or not a penalty ought to have been imposed in the first place.
I mean, the legislation does strike me as odd in the sense that, as you say, section 32(2) says the Secretary of State may do something. 32(2)(a) says, well, the may doesn't allow you to go beyond the amount prescribed, but on the face of it, you're still in the realm of discretion.
Yeah.
And then 2b says, well, you may reduce, but if you start off with an overarching discretion, why does it bother to tell you that you may reduce?
If I were the draftsman, I would have taken out the first may under section 32(2). That would be by far the simplest way of approaching it. You have a penalty, and then the only issue is the amount that you have. And the difficulty with this legislation is that first may.
Well, is that so? I mean, it would be unusual to have a situation where you imposed a positive obligation on the Secretary of State to impose a penalty.
Oh, I'm just toying with the.
At any rate, it's there.
It wasn't as serious.
It helps you that it's there, doesn't it?
So
even though you wouldn't have put it in.
Believe me, I'm not going to run off to Parliament and demand that they.
And taking it out of your course for a moment, jumping to the end, the judge looks at it again and says, well, I'm confirming the penalties which have been imposed. But by the time you got to the judge, the penalty is £4,500 per entrant, isn't it?
Yeah.
And that's based on previous good behaviour, so to speak, and the means of the haulier.
Yeah.
So the judge approaches it on the basis that there's been a non-compliance, therefore you're not eligible for the specific reduction. Supposing that Mr. Howarth doesn't in the end persuade us that there has been a non-compliance, then the judge has approached matters on the wrong basis. So I suppose we have to look at it again.
You do.
On the face of it, because there's been compliance, you're entitled to a 50% reduction. Does it go beyond that, or would that be the answer?
You won't like the submission, but I'll go back to my original point. Why should there be
A penalty at
in
all?
the first place?
So you say, well, the judge has approached it on the basis that there's been a non-compliance. If there isn't a non-compliance, then I assume you would say we should revisit it.
Yes.
And on your case, the answer would be we should revisit it and impose no penalty.
Yes.
Yeah.
I hope that's not too controversial. I'm just looking through my skeleton argument because I think in our various
We've ranged quite
chances,
widely.
we've ranged pretty much across what I hope is everything I had intended to place before this court. And my primary arguments are contained in my skeleton argument. Unless my lords think there's something I ought to deal with that I haven't, I think that may be it from me.
Did you want to say anything more about the code of practice? Maybe not. I mean, you said that the 50% discount doesn't apply to you. because you're not a member of the scheme.
Yes.
And had you been a member of the scheme, under your interpretation, it's 100%.
Yes, well, on Her Honour Judge Coe's interpretation, I'm not adopting it wholesale, but yes, certainly that was the view that Her Honour Judge Coe case took.
Which wouldn't be obviously unfair. I mean, if you've done everything to belong to the scheme and then you've done everything to comply with the regulations, well,
I have no difficulty with a reduction if you are a member of a scheme which is designed to encourage. The difficulty, if I can put it that way, that I have is that not everybody joins a scheme. Some people don't have the wherewithal to pay to join the scheme. Why should they be unduly penalised when they've otherwise done everything they ought to do?
Well, they won't be unduly penalised.
They won't get their
Because
50%.
there's a discretion. There's a discretion.
There is, but exactly.
There's
Because
the earlier discretion,
yes,
and there's the discretion under the
have
code.
my lord has it.
So but one can see that the government might want, or the Secretary of State might want to steer people into becoming members of the scheme, because presumably the scheme is designed to provide added protection against this sort of clandestine entry.
And that's a perfectly legitimate aim. I don't disagree with that proposition. But there's a difference between steering and forcing, especially for those who don't have the wherewithal to follow that path. And in any event, regardless of whether you're a member of a scheme, if you've done nothing wrong, we're back to my fundamental complaint. If you've done nothing wrong, why should you be penalised? Regardless of whether or not you're a member of a particular scheme or club.
my lord raises the question of whether we need to look at the judgment. I mean, I suspect we've pretty much picked up your points.
Well, I've visited it all in my skeleton argument.
Yes.
I'm quite happy to go to particular parts. I'm keen not to be overly critical of the learned judge, or indeed to contrast him too strongly against his own presiding, designated presiding judge.
DCJ.
The DCJ. But I'd rather think the Lords have my points, unless.
Yes.
Thank you.
Thank you very much. Mr. Howarth.
My Lord, I seek to address you effectively on 6 points in response. In doing so, that will encapsulate my learned friend's submissions and respond to the 5 grounds of this appeal. The first ground I would seek to address you on is what issue the Secretary of State takes in relation to breach of the regulations. Second, we'll deal with the definitions as to responsible person or person responsible, or at least the Secretary of State's case as to that. The third is just dealing this. So those first 2 points deal effectively with ground 1 of the appeal. My response, my third submission deals with ground 2, and that's effectively the defence and the system in place. Number 4, I would deal with analogous representations. This isn't in response to the ground, so to speak, but it is referenced by my learned friend at ground 4. But it deals with the use of analogies such as the summary, such as smuggling, and the reference to the presiding judge's judgment from March, presiding judge's determination in March of this year.
This is Judge Coe.
Yes.
He's actually, as I said before, the DCJ. He's not the presiding judge.
Apologies.
Yes.
The 5th submission will deal with the penalty code and discretion. That, of course, deals with grounds 4 and 5 of the appeal. And then last, very briefly, I will deal with accreditation and how His Honour Judge Owens deals with that in his judgment.
Very sorry, I didn't hear that.
Number 6 is to do with the accreditation scheme.
Scheme.
The scheme itself, yes. But your lordships, I trust, will have seen the skeleton argument, and the primary case I advance is that His Honour Judge Owen's decision represents no error of law. The Secretary of State would ask that this appeal be dismissed on all 5 grounds. Dealing with my first submission in relation to what the Secretary of State's case is, that is dealt with in the original trial bundle within the IS-11. This is the notice that was sent to the appellant, outlining, albeit incorrectly at that time, what the penalty was, but detailing where the breaches are alleged to have occurred. And your lordships have rightly referred to that document, my own friends, beginning argument that he states in his submissions, with respect, of course, he argues that the appellants have not been told where they have breached the regulations. I'd respectfully disagree with that, and I'll take you to the regulations in due course, which you will see at page 41, which is the IS 11.
I'm probably looking in the wrong place. I've got an IS 11 in the core bundle starting at page 114, and the relevant bit seems to be page 117.
Yes, so there is the civil penalty notice and the IS 11 within, and the IS 11B within the core bundle. I'm referring to the original trial bundle because it will come relevant
Oh, I see.
in a moment.
So let me try that. So, sorry, what page is that?
So within the trial bundle, it's pages 41 and 42. It's just easier to refer to this bundle because I'm going to refer to it again in a moment to see us jumping between bundles. So this is my first point as to what the Secretary of State's case is, and that is detailed at paragraph 10. This is in reference to breach of 2E2. States the checklist provided on the day of the incident shows no checks within 24 hours of the incident. My learned friend's submission was that the Secretary of State has failed, and of course then by proxy the judge has failed to identify where the breach occurred under 2E2. My lords, you will be familiar with 2E2 now. It references within subparagraph 2A
Yeah.
So I'm just taking myself to the entry. It refers to 2B, 2B2, 2B3, 2B5, 6 and 7, and then of course 2C3. Your Lordship referred to the fact that each of these entries state before the journey, but that is not the case in relation to 2B3. If I can take your Lordship's to 2B3, that is somewhat different, and this is where essentially the hammer falls in relation to the appellant and the respondent's case, because although this was referred to by my learned friend's submissions, it was not. You were not, my lords, taken through the paragraph to the very end.
So we're on 2B3 on page 60.
Page 60, yes, my lord, I'm grateful. So if I may just read that, it says, where the goods vehicle is equipped with a TIR cable or strap, the owner, or as the case may be, hire, must ensure that the TIR cable or strap is in good working order before the journey, before the vehicle begins any journey. So that is the differentiation to the other regulations where it says before the journey. This is any journey, before any journey, and that can be at stops along the route. And this is relevant because when I take you then to the checklist supplied by the appellant driver in the first appeal, you will note that there's an absence at entries 7 and 8.
Why is that? Why does that apply to stops?
So that applies to stops. It's in relation to the checks carried out by the driver. And then, of course, this is relevant to the owner. So it's on any journey. So that refers to the stops along the journey also.
Why?
Sorry, my lord.
Why does it apply to stops?
So it applies to stops because it's obviously the purpose of 2B is the actions to be taken in relation to securing a goods vehicle against unauthorised access. And it's essentially a recording what the requirement is, or the action under 2B3. And that's a requirement of the owner.
2B2 says before a journey, and 4 says before a journey, and 5 says before a journey. So why is 3 different?
Well, I'm taking my own friend's case at its highest. He states that each of these says before the journey, so the only input the owner could have was when it leaves the depot.
Why does this apply to the owner in this case? Because on page 39 in the trial bundle, it says that this doesn't apply to 2B3.
So yes, so this is where it's different in relation to was there a breach of the application of securing the vehicle by way of tilt cords or otherwise. So there's the differentiation. Even if they've complied with 2B2 or 2B3, the record must be completed along the journey.
I think the Lord's point is that it says it doesn't apply, which is presumably because it's not equipped with a TIR cable or strap.
And even the record of that must be within the checklist. And that's the Secretary of State's point. The Secretary of State does differ from another friend's point saying before a journey. Secretary of State's case is, no, that is still an obligation on the owner or the hire at every stop, because each stop and then setting off is a journey.
So can I just break it down? First of all, do we know that this vehicle was equipped with a TIR cable or strap?
It wasn't.
It wasn't.
My understanding was that it doesn't apply if my friend.
It was a box.
It was a box.
So, I'm sorry. I'm sure it's me, Mr. Howard, but why is this relevant at all?
So the point I'm making is taking my learned friend's case at its highest. He's essentially said each of the requirements under 2E2A is before the journey. So as setting off from where the owner is or the hire at the depot. The Secretary of State case is obviously different on that, saying it's every single journey along the route.
So can I just break it down? I'd got the impression that you were drawing a distinction between a journey and any journey.
Yes.
But if there's any validity in that distinction, that only applies in relation to 2B3, and 2B3 doesn't apply at all because this isn't a vehicle with a TIR cable or strap. There can't have been an obligation to record a check in relation to a TIR cable or strap because it isn't equipped with one.
Yes, I take that point. The point I'm saying about is how the regulations apply in general. Obviously, to this appellant, based on the IS 11, there isn't that strap, so to speak, or the TIR. It doesn't apply. But in terms of the actual application of the regulations and how that obligation is still on the owner, on the hire along the journey.
Well, can I just try breaking it down? So there can't have been a breach of 2E2 in failing to record a
B2
check in accordance with 2B3 because 2B3 didn't apply.
At least the Secretary of State's case says there should be a record of any checks being done whatsoever, even if it is under 2B3, which doesn't apply.
But why would you have an
2B
obligation to check under 2B3 when it doesn't apply? It says where the goods vehicle is equipped with a TIR cable or strap, the owner has to ensure that the cable or strap is in good working order. But if there isn't one, then you can't have to check it. And therefore you can't have to record that you checked it.
So I do obviously take your lordship's point, but the point of the Secretary of State is that there must be a record of it being applicable or otherwise.
But that's not what the regulations say. It doesn't record that you're not obliged to record whether the regulation applies. What you're obliged to record is that they have ensured the action has been taken.
Yes.
And there is no action to be taken.
Not in relation to, not in relation specifically to this appellant.
But this, as I understand it,
case.
this is the one you say they breached.
I'm saying taking my learned friend's case at its highest, if you were reviewing the regulations itself, he says obviously before a journey being on any obligation on the owner, it only essentially arises when they're leaving the depot because then it's in the hands of the driver and that obligation of the driver is separate to the owner. My submission is hypothetically that's not necessarily the case. Even taking the appellant's case at its highest, you could apply that individual regulation if it's applicable. Obviously, it isn't in relation to KLG.
But if we can just part for the moment, and you've qualified all your submissions so far by the expression taking his submissions at its highest. But if we look at what actually happened in this case, and we look at the bundle we're looking at now, 41.
Yes.
So, which helpfully sets out what the obligation is under 2E2. As soon as practicable afterwards, the owner or hirer must record in writing that they have ensured that actions set out in those regulations, as applicable, have been taken.
Yes.
If the regulations don't apply,
Yes.
why is there an obligation to for them to record anything.
In these circumstances, if not applicable, then they don't have to record them.
Okay. So what does the check? What does that? What the border forces? It is border forces, isn't it? What the Secretary of State is saying here is that the owner did not comply with regulations. With that, and the explanation is no checklist within 24 hours of the incident. So,
And that falls back to the main submission as to compliance with 2E2 is that essentially, I know the differentiation is made before a journey. The Secretary of State's position is that that's every journey along the stop, along the route to the United Kingdom.
So this isn't a 2B3 point. This is a 2B point generally. You say
Yes.
before a journey means before
Yes,
each leg.
yes. I'm just differentiating, obviously, a hypothetical situation than an applicable situation, because of course, as your lordship's correctly said, it's where it's applicable.
So just you set out from Marseille, you're heading to Calais, you stop at a service station somewhere on the motorway. On your construction of the regulation, when you start on the next leg, that's before a journey.
Yes. And that's how the checklist is drafted. Effectively, there's a number of stops, which are a number of journeys.
so
along
which
the route.
regulation in this case did this owner fail to comply with?
So 2E2 generally, in the sense that there's a failure to make record.
But doesn't there have to? I'm sorry, I'm sure it's me, Mr. Howe. Doesn't there have also to have been a breach of the earlier regulation, or at least one of the earlier regulations?
Your lordship will say, of course, there's no checks conducted whatsoever.
But shouldn't that therefore be recorded? You see, and again, forgive me if I'm wrong, Mr. Howe. I may be wrong to say so clearly if I am. If we go back to 39, the obligation under 2B2. Oh no, let's take 2B3, okay? 2B3, before a journey. 2B, that phrase appears. So the journey, so if you're right, surely there should at that point have been an infringement, because the obligation arises, doesn't it? If you're right, each journey applies. Every time the vehicle stops and for overnight, and then another journey starts.
Yes.
Then why isn't some breach of regulations recorded? If your theory is right, what this document shows is there were no breaches except for the records breach.
Yes.
So how does that work?
Effectively, they've failed to record that they've done these checks.
Can
And
I
that's the important point, because then there was obviously, sorry.
can I make that specific? If we look at the second supplemental bundle, page 137, we get the fully completed form.
Yes.
And if we compare that with what you got, we're missing stops 7, 8, and possibly the final check.
Yes.
137 in supplemental 2. Now, if we look at stop 7, it says location, that seems to say Calais.
Yes.
So you've already got to Calais. So where's the next journey? Before a journey, they have to carry out a check.
So there's, you can see the next journey identified in the document at 137. I can't read that effectively, but there is another location. So my submission is that each location is a different journey from point.
So it's not merely
6 to
stopping
7.
at the service station. It's if you stop at one place in Calais and go to another place in Calais, that's a new journey.
Yes, because of course there's an obligation to the driver to conduct checks along the journey. And there's reference to that in the IS 11.
Can I just
At-
assist? Transmark is the ticket retailer for the ferry.
My learned friend's been very helpful in saying it's Transmark is the ticket.
And
Terminal.
so sorry, what is Transmark?
I've been
Oh,
understanding it's
I
a ticket
see.
terminal.
Yes, please.
Transmark is a company that sells tickets to haulage companies, and you go to their terminal at Calais to collect your ticket.
So these places along. So Troy, is that Troy first?
Troy and then Latour.
Latour.
Yeah.
Heard of that. And Port Calais, whatever that is, transmarket again.
Yes.
Give me-
In the harbour area.
It's, no, the answer to this, isn't it, is that 2C2 expressly deals with stops along the way.
Yes. 2C3, my lord.
And it's the driver who must, during each occasion the vehicle is parked during the journey, perform the standard checks. And the journey is defined in, or relevant journey is defined at page 58 as the journey during which the clandestine entrant became concealed in the vehicle. So what we're doing is they set off on the journey, and at some point during the journey they stop, they park. And the obligation when you park or stop is 2C2.
Yes.
And that is not contained within 2E2. It's contained within 2E3.
Yes. 2C3 is contained, and that's referenced in IS11, and it also says where at any point during a journey before the goods vehicle enters the United Kingdom, the person responsible for the goods knows there's reason to believe that a means of entry of vehicles load space has been opened. The person must ensure that the standard checks are performed.
Yes.
The Secretary of State's case here is how can the responsible person have the knowledge or otherwise or suspicion if the checks haven't been done and recorded.
Because they might see somebody hopping into the lorry.
I mean, I can see if there was indeed reason to believe something, then it ought to be recorded. But you don't allege there was reason to believe anything, so why should it have been recorded?
Because there must be a record under 2E2, and not of course 2E3 in relation to the driver, but 2E2 in relation to the owner hire. Because the Secretary of State's case is that it's a delegated duty, where the owner or the hire is not driving the vehicle, they delegate that to the driver. So this feeds in somewhat to my second submission about responsible person or person responsible. I know there's the sort of difference in how the word's placed. Secretary of State's case is it's the same meaning as
So
to driver, owner, hire.
saying that whenever you, at any point during the journey, you must record that you don't have reason to believe?
It's basically whatever the obligation is under Regulation 2C3.
This doesn't only apply at stops, it applies at any point during the
Yes.
journey. So you'd be having to make a continual note throughout the journey.
But the point being is they couldn't comply with that if they hadn't kept the record at all.
Well, they could comply with that. You say they didn't comply with the record keeping.
Yes, the 2E2 point,
I
which is
don't imagine
effectively
they didn't comply with the underlying obligation.
because it says owner has complied with this regulation in relation to 2C3, but there's no record effectively of that within the checklist.
So the obligation under 2C3 to make standard checks only arises when a person knows or has reason to believe that entry has been, the space has been opened. That's when you have to undertake a check. It's only if you've, if there's a, why is there an obligation, why is there liability on the owner in those circumstances? If there hasn't been, if there's no reason to believe, because there's no reason to believe that the space has been opened, why is there an obligation to check?
The point effectively is there's not a record of it, and that goes to the compliance issues, the record keeping.
I have to say, I can't see how this works. If we look at the notice, that explains that the owner has to record that they've ensured that the action taken out in Regulation 2C3 has been taken. So we then look to 2C3 to see what action needed to be taken under 2C3. And that says that if you know or have reason to believe there's a problem, then you carry out the standard checks. So if you know or believe that there's a problem, you have to carry out the standard checks and you have to record that you've carried out the standard checks. But if you don't think there's a problem and have no reason to believe there's a problem, there is no obligation to carry out the standard checks. And therefore, there's no obligation to record that you've carried out the standard checks because you didn't have to.
Well, Secretary of State's case is effectively that they're, even though it says it's complied with this, because the driver may say, oh, I walked on and I checked, or in this instance where that's delegated to the driver from the company. So the driver says, I've walked on and checked, I have no reason to believe. The point is, well, you haven't recorded, you have no reason to believe, even if you say you've gone around and checked. So it's solely the record keeping point.
Okay, so just looking at the individual, to underline my lord's point, what happened in this case, page 40 in the bundle you were looking at, so that's where the core bundle. There it says that under the obligation under 2C3 had been complied with.
2C3.
Yeah, that's what it says, page 40. It had been complied with.
Yes.
So even though the obligation had been complied with, because the checklist showed no checks within 24 hours, the obligation under 2E2 had not been complied with.
Yes. In relation to the owner and hire who was not with the vehicle at the time.
So let's be clear, we're only concerned about checks 7 and 8 or whatever it is.
Yes.
So the thesis is that at stop 7 in the Port of Calais, when the owner and the driver had no reason to believe there was any problem, not merely was the driver obliged to carry out the standard checks as is expressly provided for under 2C2, but there was an obligation to carry out checks under 2C3, but there wasn't because you say that's all right. So I don't quite see how it works.
So, my lord, it's simply the keeping of that record, the contemporaneous or the 24-hour record from when he at Calais to the ticket office, effectively, because of course the driver is compelled to keep the owner's and the driver's record in the vehicle under 2E8.
What's the magic in the 24 hours?
I believe that just relates to the actual checklist itself, because on the checklist, which was actually provided, there was no check within 24 hours. So then that's the compliance of 2E2. May I turn my back very briefly?
Before or after?
24 hours before in the lead up to, because that would be points 7 and 8 in the falsified record. May I turn my back very briefly? Sorry, my lords. Yes, so that 24 hours is just in reference to a compare and contrast, effectively. This is the point I'm making. If you compare and contrast the falsified one to the actual one recorded, there's no 7 and 8 checks. So that's why it's just particularising the breach of 2E2.
So we go back to 137 in the first supplemental bundle, where we get fully completed version.
Yes.
Stop 6 was, I think, on the 23rd of February. And then the next stop would have been on the 24th of February.
Yes.
So there is a 24-hour interval. But there's no complaint about what happened on the 23rd of February.
Not as far as I'm aware now.
Yeah.
So those effectively are my submissions on the first 2 points I wish to raise.
Would you forgive me, Mr. Halford? I just had another go at trying, and it is me, I'm sure, trying to understand how this works with taking 2C3 and 2E2. Okay? So the obligation under 2E2, take that first, is as soon as practicable afterwards. Now, do you accept that afterwards means after the action?
Yes.
Okay. So as soon as possible, practicable, after taking the action, the owner must record in writing that they have ensured that actions under we're looking at 2C3, have been taken, and any signs noted that someone's got in
Yes.
are recorded too. That's what they have to record. First of all, that they've taken the actions required under 2C3, and they have to note any signs,
Any signs.
record any signs noted that someone's got in.
Well, not necessarily that someone's got in, but just any sign. So it could be
Any signs that someone has got in.
clear or otherwise within the checklist. Could just be signed at non-applicable or no issues.
Any signs denoted that a person has gained or attempted to gain. All right.
Yes.
Okay.
So it's any sign
So
whatsoever.
that arises as soon as practicable after they've ensured after the action.
Yes.
Now, the action in this case under 2C3 is that the standard checks were performed. Yes?
Yes.
And the standard check, the obligation to carry out the standard checks only arises where during the journey, before the vehicle enters the UK, a person responsible knows or is reason to believe that a means to entry has been opened.
Yes, but there's
So where the means to entry has not been opened, why does the obligation to carry out a check arise?
So there's effectively on the driver, so it's under 2C2, the driver must, so there's an obligation there must during each occasion the vehicle is parked during a journey perform the standard checks. So essentially the case with effectively, well that's obviously when you're doing the record keeping, but when the owner's not there, the delegated duty is to.
But forgive me, 2C2 isn't included in the list in 2E2.
No.
Whereas it is in 2E3.
Yes.
So in the circumstances where there's been a stop and the driver has done the check, then he has to record that he's done the check. And if he doesn't record that, then even though he's properly done the check, he's in breach under 2E3.
Yes.
But it isn't obvious that the owner has any liability because 2C2 doesn't bite on the owner.
Sorry.
Because that's not in 2E2A.
The argument being from the Secretary of State's case is that if there's no record done whatsoever, then the owner cannot essentially have complied with 2E2, both in terms of A and B. B being any signs, and A in relation to knowledge or reason to believe no clandestine entrant, because the record says effectively there's been no check done in relation to compliance with the actions.
That is, forgive me, the assertion that there's been no checks in 24 hours would be grounds for saying that 2C2 had not been complied with. Why is it relevant to whether 2C3 has been complied with, given that that obligation only arises in the circumstances set out in the 2C3?
The point being the owner or hirer cannot satisfy themselves with 2C3 when there's been no record of a check done. Because of course the driver states, I've walked around, I've checked this to border force, but I've made no record on it. That doesn't then indemnify, so to speak, the owner hirer, because the owner hirer still has an obligation to ensure there's checks, and they cannot be satisfied through the delegated duty to the driver of any knowledge or reasonable belief because there's no record as such.
But that would be different. I'm sorry if I'm being too much. That would be different. It doesn't say where at any point a person responsible ought to know. So if it said the person responsible, i.e. in this case the owner, ought to know because the standard checks have been carried out. But it doesn't. It says knows or has reason to believe. So why is there an obligation on the owner in these circumstances?
Because the argument being that where there's no checklist completed by the owner through the driver, they cannot have that requisite knowledge or belief because there's been no record whatsoever.
Yeah, well, thank you.
You say this is the Secretary of State's case. Can we see that? Can you show us where that's been presented in writing?
It's in terms of the actual IS11.
No, either in terms of your submission, written submissions, or in terms of the judgment.
So the submission through the skeleton argument was placed on the basis that there's just been an outright breach of regulation 2E, 2E2, because there's been no record.
Somebody must at some point have addressed why. Why is it in breach?
For the points that I've outlined, and that there's been no contemporaneous check done by the owner hired delegated to the driver.
Does that appear in your skeleton?
The point that I've made, and another friend raised it in his open submissions, was about the vicarious liability point. But in relation to the actual judgment from His Honour Judge Owens, the finding is somewhat different in that he says it's a delegated duty, and then must reference is made that I can't take your lordship to those entries within
I
the
think what
judgment.
concerns me is that it's not clear to me during the course of this whole process when anyone's actually identified which of those obligations the owner was in breach of. And you have just said 2C3. And I think you're pinning your case on that. Where has that previously been identified in these proceedings?
That's me effectively breaking it down on the regulations, but the Secretary's case has always been there's been a breach in general of 2E2 because there was no record taken 24 hours prior.
Forgive me, you surely you can't be that broad brush, can you? The regulations identify specific things the owner must do, and you're saying the owner is in breach of that.
Yes.
You must surely, on basic principles, have to particularize what the owner did that was in breach of which of them they breached. And now I think, now you're pinned down to it. The only one you can identify, am I right in saying, is 2C3.
If
that
that's
right?
the applicable one. So effectively it is somewhat a broad brush approach because
Well, no, forgive me, it isn't broad brush. You are alleging that there are breaches of regulations. Are you saying, do you accept that the owners did not breach their recording obligations in relation to 2B2, 2B3, 2B5, 2B6 and 2B7?
so the IS11 states that those were complied with are not applicable, but there was no record of them. I think the breach itself being particularised has to fall under, if we're really particularising, under 2E2B, because it says any signs, and that's both positive or negative signs.
But that's 2C3.
There's 2C3, but there's also, it doesn't reference 2C3 in subparagraph B at 2E2. So 2E2 is a separate, obviously separate paragraph, subparagraph B, any signs noted by the person taking those actions that a person has gained or attempted to gain unauthorised access to goods, vehicles, and that's where the point is, okay, you've complied with, say, arguments, you comply with 2B2, 3, 5 and 6, 7 and 2C3 along the journey, but you've not recorded any signs that anyone's attempted to gain entry or otherwise. There's just literally no record of it, and the point being,
So that's where you're putting your case now.
yes, and
where do we
IS11
find that? Where do we find that anywhere in these proceedings before now?
within the IS11 it says there's no record of checks within 24 hours.
So,
That's effectively.
I mean, so I think you're really saying, I mean, I assume that what happens is that when Border Force sees a document showing no checks within 24 hours, they infer that there must have been something's gone wrong. But now we're drilling down. So in terms of the submission a moment ago based on 2E2B, you say, well, you have to record an absence of signs.
Yes.
Well, as we were agreeing a moment ago, you have to, as soon as practicable afterwards, so as soon as practicable after the action, you have to record it. Little b says any signs noted. So if you note a sign, well, you have to record it as soon as practicable afterwards. But if you haven't noted a sign, when are you supposed to record it?
At each stop along the journey.
But it doesn't say
It's
that.
2C.
But if at any stage you noted a sign, you'd have to record it. It's not tied to a stop.
So effectively, it fits into the position of where the driver, I know it was mentioned previously, with the driver and the hire, the owner are the same person, and they're along the same journey conducting checks or otherwise. Where that's then separated with the driver and the owner, it's the obligation is collectively the same, and that's effectively the point. Although it arises individually for the driver to conduct checks at each stop, it's the point being made under 2E2 is when the owner isn't there, there has to be a record of that.
I mean, I was getting the impression that the Home Office, having devised these regulations, has botched them. Because the obligation to impose the standard checks at every stop is on the driver, and that's not imposed on the owner, and the owner doesn't have to record that either. So that's the problem.
The only other point arising from that is effectively at 2E8, where it says that the driver must ensure that a copy of the written records referred to in paragraphs 2E2 and 2E3, 2E4 and 5 are kept on the goods vehicle. And that's the only other point where it links it to the driver at the time. And that obligation, obviously the Secretary of State's case being the owner and the hire still have that concurrent duty, which is delegated to the driver to conduct at each stage along the journey.
But it's no longer in dispute that the driver failed to comply with certain obligations.
No.
He's penalised for that, and as I understand it, the appellant is picking up that bill. So when we find in 8 something about what the driver must do, well, that doesn't take us any further, does it?
It takes us further in the sense that where the owner and hire isn't there, the driver must have the owner and hire's checks under the checklist of 2E2. So that's I know I've made the differentiation, might be a side point, but differentiation in the submissions to His Honour Judge Owen, where there's an iPad system, or in this case, where we have a paper-based system, there's still a delegation of duty. And that's where the owner can have in situations where they have continued compliance with checks or otherwise, because they do it online and the owner's concurrent knowledge is more up to date in those certain situations. Whereas in this case, it's the delegation, which is different in that the driver is continuously making those checks on behalf of the owner and the hire. And that's why it really is that sort of the crossing the duties point from the driver to the owner hire when that's been delegated to him or her.
Can I have another go? Just to find that. I'm sure it's me this time. I'm not understanding it. I wonder whether a key word in this interpretation, in these confusing regulations, is the word ensure. Because what the obligation is under 2E2 is for the owner to record in writing that they have ensured that actions are taken out, okay, in the specific regulations. And the word ensure appears in all of those regulations.
Yes.
And that's the point at which it's only if they have ensured that the obligation to record arises. So if we look at 2E, and you can check through all the other ones, but specifically 2C3, which is the one you're focusing on, the obligation to ensure that standard checks are performed only arises in the contingency provided for in 2C3, which is, as we already discussed, whether the person knows or has reason to believe that a means of entry has been opened. So where there isn't, where the person doesn't know or have reason to believe, there's no obligation to ensure, and therefore no obligation to record. That's the proposition I put to you.
Well, the Secretary of State's case is obviously where there has then been a checklist completed, but it's not done to such an extent that it's diverted from the fact that clandestine entrance made his way into the vehicle. Then obviously that's where the focus of the Secretary of State lies in saying, well, have you ensured and could you have ensured in relation to your requisite knowledge or belief? And that's the submission in this case, is that, well, no, because no record was made, ensuring that the owner hire did not have a knowledge or a reasonable belief, so to speak, because it should be on the written record.
And just so I'm clear on this, if there is, why do you say that it's logical then? If there is a breach of regulation 232E2, doesn't there have to be some breach by somebody of the of another regulation? And where is it on there's nothing. There has to be a breach by the owner, either personally or collectively. That's not the word you're using. You're using another word. Anyway, we know what you mean.
Yes.
You know what I mean.
Yes.
So doesn't that have to be asserted in the notice the notice of liability? You can't. Doesn't have to be a breach of one of the other regulations as well as 2E2. Doesn't the owner have to be in breach? And there's no, according to this notice, he wasn't. It wasn't.
It may be a point of practice in terms of how it should be improved or otherwise, but at least in terms of what's been done, there's been no particularisation as to the exact breaches under 2A or B, but it is phrased that there's just been a breach because there's no record within 24 hours.
So, how are we to know that when the checklist, when the notice says, I'm sorry, I'm back on 117 again. I've lost whichever one it is. It's 30 something, isn't it? You know what I mean? The notice of liability, which is at 117 in the core bundle, 114 in the core bundle, internal page 4 of that, where it says against 2E2, the checklist provided on the day of the incident shows no checks within 24 hours of the incident. What checks, what particular regulation is it asserted the owner has broken, even though it's not mentioned elsewhere in the notice?
So in terms of my submissions on this case,
Yes.
it's particularising where the breach is. I know I've said this, and it seems it's the Secretary's position. It's just the very fact of a failure to keep a record of these checks having been completed.
The thesis is there must have been some checks and they're not in the record.
Yes, that's effectively it. And then it's
We ought to break, you've probably more or less dealt with your first couple of points, but just so I understand, if we look at the version that you got, stop 6 was it? This is a red herring, I admit, but just so I understand it. We see stop 5 was at Troy, I think.
yes.
Where was stop 6? I can see ATOU.
I think it's Latour, you said. Or maybe I was just imagining. Imagining something else. Is it Latour?
Mr. Clark, do you know the answer to that?
The second stop.
There's Latoy and then Troy, Latoy, Port of Calais,
Sorry.
and then yes.
Latoy.
It looks like LATOU, Latu to me, and then Port of Calais. If that's it.
Yes, I mean, it's just I'm not familiar with anywhere in France with that name, but that's probably my fault.
It's somewhere in France.
Yes.
It's probably the Lorry Park.
And it's
Yes.
closer than Troy, but not as far as Calais.
Yes, I follow. Is that going to be a convenient moment to break?
My Lord, just
Yes,
before
please.
I conclude, in relation to 2E2, I know I've made the point that it may not be particularised, it isn't particularised in IS11, but for saying it wasn't done within 24 hours. Again, the reference I've made to 2E2B as the one of the checks what must be conducted by, given in this instance, delegated to the driver. If you look at the list in the hypothetical checklist at page 138, 137, you can see, by looking down the left-hand column, where these questions have been posed, they relate to the regulations. So the
Good,
point
sorry,
I've
this
made
is-
about 2E2 subparagraph B, it says any signs noted that a person has gained or attempted to gain unauthorised access to the vehicle. So this standard checklist, which was adopted by the company, this one was complied with, but it's fake. It says yes, that's the 2E2 subparagraph B point. But given that this wasn't completed, there has been no record of checks in relation to any signs noted.
Can I just pursue it a moment longer? There's a definition somewhere, isn't there, of standard checks?
Yes.
Where do we find the definition?
Well, it's the very last page on my tab 5. It will be your page 71.
So if we look at the schedule there, yes, page 71
Yes.
in my bundle. So the driver periodically has to carry out the standard checks. We've seen that. And presumably, I'm guessing, 13H reflects the standard checks, does it?
It does, but it also goes over and above that by making reference to the paragraph 2E2.
So can we just
signs?
Can we just see that?
So you have at page 71, which is the 12 standard checks, stage schedule regulation 2 standard checks, and then you have the checklist, which is provided by the border force.
So the checklist you say doesn't correspond to the standard checks is different.
Yes, in this instance, it actually includes more.
Um,
It appears.
So can we just see that? So the specific one was your signs noted that someone's tried to get in. Is that in the standard checks? Yes.
Checks 2 and 11.
So if we take certainly quite a few of them, you're checking for signs of
Yes,
unauthorised access.
yes,
So in that sense, when we find that at 138,
yes.
that's reflecting what the driver has to do under 2C2, is it?
Effectively, yes.
Yes.
And then there's obviously, as I've outlined at page 138,
You are saying the owner is liable if those checks are not recorded.
yes, because that's what 2E2 says. That's the delegated duty of the owner. The delegated duty on the driver from the owner.
That goes back to the beginning, start of the journey point.
Arguably, yes, I know my own friend said it's before the journey they set off, but the Secretary of State's case is it's each one of these junctions after loading on the checklist is a journey for the purposes of the regulations.
What's the point of 2C2 then?
2C2 being the reference to the driver's obligations.
Yes.
It's mainly applicable to the driver at every single stop, effectively.
Yes. Not the owner.
No, because that's obviously the driver in the vehicle at the time, which could be the owner or the
I thought
hire.
you just
but
said that each stop is the start of a new journey, so therefore all the owner's obligations come into play.
when the checks are conducted. So that's the point about
And my question
reference
to you
to.
is, but then in that case, why refer specifically to 2C2? The driver must, if it's actually the owner must as well.
Well, the crossover for the obligation for the owner is input through 2E2. The actions of the person in the vehicle, being the driver, is 2C2. Because of course they can be the same individual as a responsible person or persons responsible.
Is that a convenient moment?
Yes.
We've gone past 1 o'clock. I'm encouraged to make it 10 past. We'll resume at 10 past. Sorry, Mr. Clark.
Could encourage you further if
10 past 2.